5 seconds to go. Start. The next issue that arises is whether the petitioner has complied with the provisions of Rule 12. As a stand-alone entity, the petitioner does right fulfill the conditions laid down in Rule 3 of the Capital Adequacy Rules. However, the Rule 3.2 also stipulates that the net worth of the promoters of the petitioner can be considered for the purpose of computation of the debt equity ratio of 30:70. The Commission, in exercise of the powers conferred under Section 14B of the Electricity Act, hereby identifies and recognizes Messrs. Sundew Properties Limited as a deemed licensee. The promoters have to contribute 30% of the total anticipated investment of rupees 89.53 crores, which works out to rupees 26.9 crores on or before 31st March 2016. Aggrieved, the appellant carried an appeal from the aforesaid order of the TSERC to the APTEL. According to the appellant, the directions of the TSERC were in excess of jurisdiction. APTEL dismissed the appeal as noticed above. It held that the TSERC was justified in ordering infusion of additional equity by the appellant to the tune of rupees 26.90 crore, being 30% of the total anticipated investment of rupees 89.53 crore as a precondition for being identified as a deemed distribution license. The operative part of the judgment and order passed by the APTEL reads as follows. While the appellant is not required to apply for grant of license, but being a deemed distribution licensee has to fulfill other technical and financial requirements as per prevailing rules and regulations of the State Commission, which is mandated to regulate the electricity business in the state, whether it is a DISCOM or any other deemed distribution licensee as in the present case. Accordingly, we are of the opinion that the State Commission has passed the impugned order with careful consideration and proper interpretation of the statute, and also considering the judgments passed by Honorable Supreme Court in Sessa Sterlite case Supra. It is this judgment and final order that the appellant has subjected to challenge in this statutory appeal by invoking the appellate jurisdiction of this court under Section 125 of the Electricity Act. Mr. Singh, learned senior counsel, appearing for the appellant, challenged the validity of the orders of the TSERC and the APTEL by advancing the following submissions. The TSERC and the APTEL erred in failing to recognize that under Section 14B of the Electricity Act, a developer of an SEZ is ipso facto and unconditionally deemed to be a distribution licensee, thus eliminating the need for a separate license application. Recognition of the status of a deemed distribution licensee is a ministerial act effected automatically upon fulfillment of conditions laid down in the SEZ Act, independent of Rule 3.2 of the 2005 rules read with Regulation 12 of the 2013 regulations. The status of deemed distribution licensee stands bestowed upon the appellant by virtue of the 2010 notification. Stop.